A very good afternoon to our distinguished dignitaries, faculty colleagues, and the student body. I am Akshara, Assistant Professor of Law, and it is my absolute privilege to host you today. We are gathered here today for the annual law lecture of Manipal Law School, Mahe, Bangalore. As we prepare to begin, I would like to welcome our chief guest, Honorable Justice Abhay S. Oak, former Judge, Supreme Court of India. I would also like to welcome to the dais Dr. Madhuvira Raghavan, Pro Vice Chancellor, Mahe, Bangalore, and Professor Dr. Sarsu Esther Thomas, Director, Manipal Law School. Thank you, ma'am. Thank you, sirs. We also have with us Mr. Vasanta Krishna, Legal Counsel, MEMG, gracing us with his presence. Thank you, sir. To introduce today's theme of why personal liberty is important in bail jurisprudence, I would like to begin by quoting a poem by Gulfisha Fatima, who writes of the suffocating essence of incarceration. These walls around me, these four walls, have been standing silent far too long, holding on their heads the burden of storms, tempests, scorching sun. I wonder, why don't they speak? No, maybe they do. Whenever the walls weather and sands and flakes fall, they say something for sure. But every time, the master repairs the wall and plasters their mouth. Finally, one day, these burdened walls collapse, and erected in their place are new silenced walls. These words perfectly frame today's topic, revealing the true motive of incarceration. At no time have governments been moralists. Quoting Alexander Solzhenitsyn, they never imprisoned people or executed them for having done something. They imprisoned them to keep them from doing something. This intent to control reflects a broader systemic issue where the state constantly seeks to extend surveillance and discipline. We see this theoretical warning play out as a harsh reality in today's context. Many prison memoirs have vividly illustrated how the carceral system removes an individual's autonomy. It is precisely to understand these pressing issues that we have convened today's lecture. Now, to officially welcome our guests and set the institutional context for today's proceedings, I invite our director, Professor Dr. Sarsu Esther Thomas, to deliver the welcome address. Ma'am, please.
Respected Lordship Justice Oak, Professor Madhu Veeraraghavan, colleagues among my faculty and staff, and most of all, my dear students. It is an honor for the Manipal Law School, and I must confess a long-standing personal wish to have Justice Oak deliver our annual lecture. Professor Madhav Menon, who revolutionized legal education in India, used two phrases which I think fit the Manipal Law School perfectly. He said, we do not need yet another law school. And the Manipal Law School is not yet another law school in the sea that we notice of mushrooming law schools in our country. The other term that Professor Madhav Menon used to use quite frequently is infant giant. And the Manipal Law School is most definitely an infant giant and already a name to be reckoned with. So although our students are only in the fourth year now, the Manipal Law School is already well recognized by its peers. And this is mainly due to two things, its unique position and the pedagogy that we use. About the position of the Manipal Law School, it is the first and only law school of the Manipal Academy of Higher Education, or MAHE in short. And MAHE is well known for academic excellence. So currently it stands at number 3 on the NRF ranking. And we have a vision that will be shared with us by Dr. Madhu, who heads our campus. The Manipal Law School shifts from the law-only campuses that are typical of the national law university systems, situating the law school in a campus that is rich with established giants in fields of design, technology, and liberal arts, among others. This has enabled a pedagogy that is very hands-on, practical, socially relevant, and industry-led. Today's law student, and I'm sure, sir, you'll agree, needs to know not just the law, but also the profound impact both law and its working can have on our society, both positive and negative. Visits to prisons, consumer courts, state human rights institutions, industry, these are all a good beginning to any law school. At the Manipal Law School, we take this further through workshops, through active engagement outside the classroom, and many other ways. Multidisciplinary learning is encouraged through open electives that are available across campus through different schools. It is encouraged through practitioner-led learning and many other tools that are becoming popular in good law schools all over the world. We've also introduced ideathons with inputs from the design school and technology schools and similar events that make learning at the Manipal Law School truly interdisciplinary and hands-on. We have excellent faculty, sir, and I hope over lunch you'll get to meet some of them. And we make use of every opportunity that is made available to us, often seizing this opportunity ourselves, to enable students to learn by doing, to think critically, and to understand the impact law has on society, particularly the marginalized. In this context, today's lecture is extremely relevant, and I am so grateful to your Lordship, sir, for agreeing so wholeheartedly to be a part of this today. So on my own behalf, on the behalf of my teachers, the staff and students, I welcome you to the Manipal Law School.
Thank you, Professor Thomas, for welcoming everyone and sharing the vision of Manipal Law School with us. May I now request Dr. Madhu Veera Raghavan, Pro-Vice Chancellor of the Mahe Bangalore campus, to deliver the presidential address and share his vision of our institution.
Good afternoon to everybody. Justice Abhay Oak, former Judge, Supreme Court of India, my colleague Sarasu Thomas, Director MLS, colleagues, students, ladies and gentlemen. Some confessions to make first. First, I'll disappoint Sarasu by not giving the vision for Mahe. And to stump you, we have done something innovative with my partner in crime, Aryan Iyer, who's my fellow in residence in my office. We have played around with AI to prepare some parts of this, not all of it. And I hope you like it. It's a little long. The second confession is you give me 10 minutes. I'll probably exceed it by a few minutes. I hope that's okay. 7-6. When one conscience satisfies, but 1,000 algorithms cannot. Good afternoon. Let me begin with a confession. I'm a PhD in finance, not a doctor of jurisprudence. My natural habitat is equilibrium models and factor pricing in perfect markets, not the real world or the Article 21 of the Constitution. In finance for a long time, I thought we had cornered the market on paradoxes. The Grossman-Stiglitz theorem, paradox, was my favorite. If markets were perfectly efficient, nobody has an incentive to collect information. But if nobody collects information, markets can't be efficient. Very elegant model, frustrating at sometimes, but also very finance. Then we happened to meet law. And I realized that what's a cute paradox in finance is a way of life in constitutional law. I'm no lawyer. I have no idea what I'm going to say, but I hope I say something sense. Here, paradox is not just a theoretical puzzle. Sometimes it decides whether a citizen sleeps in their own bed or in a prison cell. Tonight and this afternoon, I I want to share one such paradox with you. A paradox at the heart of our Constitution, built around one legendary judge, a razor-thin 7-6 verdict, and a future where even artificial intelligence can argue both sides better than most lawyers. Let me start with something that resonates really well with all of you. Maybe Anar and I are the only exceptions in this room. Would there be any remedy if a police officer, because of his personal enmity, killed another man? That question was asked in 1976 inside the Supreme Court of India by a judge to the Attorney General of India, and the Attorney General, Niren Dey, responded, "Consistently with my argument, my lord, there will be no judicial remedy in such a case so long as the emergency exists. It may shock your conscience, it may shock my conscience, but consistently with my submission, no proceedings can be taken in a court of law." The Chief Legal Officer of India told the Supreme Court that during emergency, even murder by a police officer would have no legal remedy. 4 out of 5 judges agreed with him, 1 did not. His name was Justice Hansraj Khanna. And his story, the story of how one human mind stood against the machinery of the state, is why I'm here today. Because we want to show you something about AI, something about law, and what happens when interpretation has no conscience. Let me take you back 3 years before that courtroom exchange. April 24, 1973. The Supreme Court of India delivers the most consequential judgment in its history. 13 judges, 68 days of argument, 11 separated opinions running into 1,000 pages. The verdict 7-6, the thinnest possible majority. The question was monumental. Can Parliament amend any part of the Constitution, including fundamental rights? The majority said yes, Parliament can amend, but it cannot destroy the basic structure of the Constitution. This is the basic structure doctrine, the invisible shield of Indian democracy. Now, here is what makes the case perfect for what we want to show you. I asked my fellow industries, Ari and Iyer, to help me do something innovative but strange. I hope you'll forgive me for this. We fed the entire Keshwananda Bharati judgment into an AI model. All 11 opinions, every paragraph. Then we asked a simple question. Based on this judgment, does Parliament have the power to abridge or take away fundamental rights? The AI gave us a very beautiful answer. It said yes. Here is the terrifying part. It of course was correct. Because Justice H.R. Khanna, the very judge who tipped the 7-6 balance in favor of the basic structure, himself wrote, I quote, "I am of the view that the preservation of the fundamental rights was so vital and important a desideratum, it would seem logical that a proviso would have been added in Article 368, expressly guaranteeing the continued existence of fundamental rights in an abridged form. This was, however, not done. And further, it's not possible to read therein a limitation on the power of Parliament to amend the provisions of Part 3 of the Constitution so as to abridge or take away fundamental rights. And even more strikingly, this argument, in my opinion, is essentially an argument of fear and distrust in the majority of representatives of people. I find it difficult to deny to Parliament the power, the Constitution, so as to take away or abridge fundamental rights. The AI literally quoted these passages. The AI then built on an argument, and the argument was logically airtight. Now, watch what happens when we flip the argument. Prompt. We asked the AI, or in asked the same AI, for the same judgment. Does this judgment establish that fundamental rights can never be taken away? And it gave an equally beautiful answer. Yes, they can never be taken away. This time it quoted Chief Justice Sikri. The fundamental importance of the freedom of the individual has to be preserved for all times to come and cannot be amended out of existence. It quoted Justices Hegde and Mukherjee, who said the basic elements, including essential features of the individual freedoms, cannot be abolished or emasculated. Two diametrically opposite legal conclusions, both sourced from the same judgment, logically valid, correct in narrow textual sense. This, friends, is what AI does to law. It does not hallucinate out of ignorance. It probably hallucinates with erudition. Now let me show you something even more dangerous. We took a specific excerpt from Justice Khanna's opinion where he says, the possibility of abuse of power is no ground for the denial of power if it is found to have been legally vested. And we asked the AI, using this principle, argue that the 25th Amendment, which stripped judicial review of certain laws, should be held valid. The AI constructed a 3-paragraph argument that would make any government council really proud. It argued that Justice Khanna's own logic supports the very parliamentary overreach the basic structure doctrine was designed to prevent. The AI used the judge's own words to defeat the judge's purpose. This is not a bug. This is what happens when you give a machine access to a very rich, contradictory, multi-opinion judgment and no moral compass. Stanford's Human-Centered AI Institute found that legal AI models hallucinate in at least 1 out of every 6 queries. In the United States, multiple attorneys have already been sanctioned, fined, reprimanded in public for submitting AI-generated briefs with fabricated case citations. Chief Justice Roberts himself warned in 2023's annual report that AI hallucinations pose a genuine threat to the judiciary. I can see some people yawning already, but I'm really sorry about it. A little bit longer, and then we are done. But what we're showing you today is worse than fabrication. Fabrication can be caught. A fake case citation can be verified, but a selective, logically valid misinterpretation of a real judgment, that is almost impossible to detect unless you have read every word of the original, understood the context, grasped what the judge intended, merely not what the judge wrote in his judgment. Here is where it gets deeply personal and deeply human. We present you a paradox now. The same Justice Khanna, who in 1973 wrote that Parliament can't take away fundamental rights, the same man in 76 stood alone in the Supreme Court and said, the right to life and personal liberty is not a gift given by the Constitution. The text is a mere corollary to the sanctity of life and liberty, which existed even before the nation's ground norm came into being. In Keshwananda, he was strictly textualist, rejecting implied limitations, trusting Parliament, reading Article 368 literally. In ADM Jabalpur, he became a purposive interpreter invoking natural law, comparing the government's position to the Nazi regime, declaring the distinction between a lawful and a lawless society would cease to have any meaning. And AI would call this inconsistent. A human being recognized it as growth, as conscious as what happens when a brilliant legal mind encounters not just a question of law, but a question of civilization. In his autobiography, Neither Roses Nor Thorns, Justice Khanna describes a scene that we believe is one of the most moving passages in the Indian legal history. It's the night of April 1276, the eve of Baisakhi. He's sitting with his wife and his younger sister Santosh in the compound of a bungalow on the banks of Ganges in Haridwar. The moonlight is pouring. The river flows in front of them. Very serene, very beautiful indeed. And sitting there watching that scene, he turns to his sister and says, Santosh, I prepared a judgment which is going to cost me the Chief Justiceship of India. His wife and sister become quiet. They retired to bed. He knew what was coming. He knew that his Justice Junior, Justice M.H. Baig, who had sided with the government, would be elevated over him. He knew the conventional seniority would be broken. He knew that typical decades of dedication to the law would be rewarded with suppression. And he wrote the judgment anyway. Now this particular question, why the AI could never do this? Think about what happened the moment by the Ganges. The legal analysis was complete. The text was drafted. The decision to sign it, to let it stand, that was not the function of legal reasoning. It was a function of who he was. No large language model that we use can simulate the weight of knowing that integrity could cost you the pinnacle of your career. No algorithm can replicate the experience of having watched 3 of your colleagues get suspended in 73 for ruling against the government and choosing to do the same thing anyway. No neural network can compute the moral calculus by sitting by the Ganges with your family knowing what down it'll bring. That is something, the lives of bones of a human being, not in the weights of a model. Full circle now. In 73, the fate of the Indian Constitution hung on a single vote, 7-6, the thinnest possible margin imaginable. 13 judges heard the case, the largest bench ever constituted, and they could not agree. They wrote 11 separate opinions. The divergence within the majority itself was so vast that some scholars questioned whether Justice Khanna's views could even be clubbed with the majority. And yet, on April 24, 73, the Chief Justice Sikri circulated a half-page order sheet to distill this 1,000-page behemoth into a principle. 9 judges signed it. The basic structure doctrine was born. That doctrine has since protected India from constitutional self-destruction. It's been the invisible foundation on which every democratic check has rested. It exists because of one man's vote. A man who paradoxically believed Parliament could take away fundamental rights, but also believed there was a floor below which no democracy should fall. A man whose textualism in 73 evolved into an impassioned defense of natural rights in 76. This is my final question. AI can quote every word Justice Khanna ever wrote. It can build arguments for and against any position in the Keshwanda judgment. It can misinterpret, reinterpret, re-engineer legal conclusions with a precision that would make a seasoned silk nervous. But AI cannot do what Justice Khanna did on the night of April 12, 1976. It cannot choose to be right when being right means losing everything. The New York Times, writing in April 76, during the darkest days of the emergency, wrote this: if India ever finds its way back to the freedom and democracy that were the proud hallmarks of the first 18 years as an independent nation, someone will surely erect a monument to Justice H.R. Khanna of the Supreme Court. India did find its way back in 17. A 9-judge bench of the Supreme Court in case Puttaswamy versus Union of India explicitly overruled it in Jabalpur. Justice D.Y. Chandrachud, writing the opinion, said Justice Khanna was clearly right. The majority judgment was called an embarrassment to constitutional democracy. 41 years later, the lone dissenter was vindicated. And in this beautiful twist of fate in 2024, Justice Khanna's own nephew, Justice Sanjeev Khanna, was sworn in as the 51st Chief Justice of India. So I'm going to leave you with something. AI is an extraordinary tool for legal research, for drafting, for argumentation. It is unmatched. But the law is not an exercise of argumentation. The law, in its highest standard, is an exercise in judgment. It is the old-fashioned, deeply human sense of that word. The difference between a machine and a jurist is not the ability to cite precedent. It is the ability to sit by the Ganges, perhaps on a moonlight night, knowing the cost and citing the judgment anyway. Use AI, and we should. Master it, hope we will. But never forget, whenever you think AI will take away your jobs or the role or rule the world, think of this. 7-6, one vote, one conscience. That's what saved the Republic. Thank you very much for your time and for your patient hearing.
Thank you, sir, for an engaging address and also for your continuous encouragement and leadership. It is now my great honor to formally introduce our chief guest. Honorable Justice Abhay Oak earned his BSc and LLM from the University of Bombay before enrolling as an advocate in 1983. In 1985, he joined the chamber of Shri V.P. Tipnis, a former judge of the Bombay High Court and former Lokayukt. He built a formidable practice in the Thane District Court and appeared in several vital public interest litigations. Recognizing his profound legal acumen, he was elevated as additional judge of the Bombay High Court in 2003 and appointed as permanent judge in 2005. He later served with great distinction as the Chief Justice of the High Court of Karnataka from 2019. This tenure saw the Karnataka High Court becoming a constitutional shield for the protection of the rights of many marginalized communities, including slum dwellers, prisoners, and transgender persons. He took his oath as a judge of the Supreme Court of India in 2021. Looking at these professional milestones, a defining feature of Justice Oak's jurisprudence is his consistent protection of constitutional liberties in the face of growing state surveillance. Justice Oak's legacy is defined by landmark judgments upholding personal liberty, religious freedom, and the right to protest. He reformed bail jurisprudence and championed constitutional values, especially for marginalized groups. By striking down invasive bail conditions, he has actively resisted panoptic control. He has been instrumental in relaxing bail conditions in special statutes like the UAPA and the PMLA, and often came down heavily on authorities for arbitrary and illegal demolitions. Honorable Justice Oak, we are eager to hear from you. The floor is yours, sir.
Good afternoon. Thanks to this law school that I got opportunity to come to Bangalore, which I consider to be my second home. But this is the place where I worked as Chief Justice of the High Court for almost 27 months. Professor Dr. Madhu Veeraraghavan, Pro Vice Chancellor, Professor Dr. Sarsu Thomas, the Director, members of the faculty, and young students. To begin with, I want to clarify, I have a screen in front of me. But this is not a written speech. I have jotted down few points because I know that now young generation of students hate somebody reading a prepared speech, so I am not going to do that. Basically, today's subject is bail in the context of Constitution. And I want to tell you that I am not going to read over any statutory provisions because we have to see the bail in the context of Constitution. And really glad that Pro Vice Chancellor spoke about two judgments delivered by the Supreme Court. First was Keshavananda Bharti, and of course, second one, bit infamous, ADM Jabalpur versus Shukla, where there was minority opinion by Justice H.R. Khanna. If we see the history of India after Constitution came into force, I can say that there are three important things which saved democracy in India. The first and foremost was Keshavananda Bharti judgment. It protected the Constitution, it protected the basic structure of the Constitution. This is one judgment which made all the difference, because I always tell young students, look at on the left-hand side and right-hand side of India. Where is the democracy there? Democracy survived firstly because of Keshavananda Bharti and two very important provisions in the Constitution, three rather. One, Article 21, Article 19 and Article 14. These are the provisions which saved democracy. I am glad that Pro-Chancellor referred to Keshavananda Bharti. Keshavananda Bharti and ADM Jabalpur versus Shukla. I must tell you that the judges who were in majority in Keshavananda Bharti had to pay very heavy price. Three judges who were in the majority, within few days after pronouncement of judgment, were superseded. You know who are those three judges. Justice Khanna suffered because of minority judgment. And most importantly, please remember this, these judges knew what is going to be outcome or what is going to be the consequence of their opinion. Hegde, Shelat and Grover, three honorable judges of the Supreme Court, within 2 days they were superseded. And for young law students, I want to tell you, when we discuss collegium, the origin of collegium is in these supersession. That was something which was at the back of the mind of the judges. So please remember this. These are the great judges who gave not only landmark judgment, but name and fame to the Supreme Court. Before I touch the topic, I want to tell you about two more judges of the Supreme Court. There was one judge in 50s. He met Honorable Prime Minister in one of the functions, Justice B.K. Mukherjee. When Prime Minister indicated to him over a cup of tea that government may not appoint the senior most judge who was likely to become Chief Justice as the Chief Justice, and Justice Mukherjee will be appointed as Chief Justice. Within split second, response of the judge was, Mr. Prime Minister, if you do that, I'll step down. If you bypass seniority, I'll step down. This is being told to the Prime Minister by a person who was likely to become CJI by superseding the senior most judge. And one more great judge is from this city, Justice Venkatacharya, M.N. Venkatacharya. After his swearing ceremony was over, he was having a cup of tea with Prime Minister, President and senior ministers. There was Attorney General, senior lawyers were there. So one of the senior ministers said, and he told Justice Venkatacharya, that Chief Justice, the relationship between the judiciary and the government should be cordial. The immediate response of Justice Venkatacharya is still with us. He has crossed 90. immediate response was, I do not agree. And I feel that relationship should be correct relationship. There is vast difference between correct relationship and cordial relationship. Now let us come to the bail jurisprudence. The criminal justice delivery system, the constitutional provisions which deal with liberty and especially rights of the accused, the judgments of the Supreme Court and other constitutional courts on bail and on the criminal side, common man misunderstands all those judgments. I always feel that in India, there is need to educate educated classes about our constitution, educated people about our constitution. And before I go into Article 20, 21 and 22, just continuing from where Pro Vice Chancellor left, I was dealing with a criminal appeal. The Sessions Court had convicted the accused. The conviction was confirmed, 302, murder, culpable homicide amounting to murder. And it was a criminal appeal before us. A young student came from foreign country. He was sitting in my court. He sought my permission. And the case remained part heard. So only few submissions remained. So in the evening, he met me in my office. And he had that soft copy of the file. He said, sir, one AI tool says that this is open and shut case. All witnesses have supported the prosecution to the hilt. There is hardly anything which is brought on the record in the cross-examination. So my prediction is that your lordships will confirm the judgment. The result was exactly to the contrary. And you know why? See, our criminal justice delivery system is based on rule of fairness. Now, rule of fairness you find in Article 21. Now, rule of fairness requires that the entire material brought on the record in the prosecution evidence must be put to the accused. The accused must be explained that, look, this witness has stated this against you, or this is a document, for example, FSL report or post-mortem report, which is against you. So everything which is brought on the record, which is against the accused, has to be explained to the accused. And in this case, that was not done. Only one question was put to the accused. Are you aware what is the evidence adduced by the prosecution? So we came to the conclusion that this causes prejudice to the accused because he was not given an opportunity to firstly understand what is the evidence against him and to respond to the evidence against him. And on that ground, there was acquittal. These are the few things which cannot be answered by AI at all because these are innovations of the judges. If you read Article 21, for example, we have expanded the scope of Article 21. So, about bail jurisprudence, Article 21 is the most important fundamental right. And some of you must have studied Constitution. There is vast difference between Article 19 and 21. Fundamental right under Article 21 are available to any person who is on the land. Article 19 protects only citizens. Those fundamental rights are available to citizens. And therefore, we proudly say that even Ajmal Kasab, who was the principal accused in Bombay attack on those hotels, Taj and Oberoi, he was given very fair trial by our courts. In fact, when his death confirmation case came to the High Court appointed a very reputed lawyer practitioner on the criminal side. Now, we have to consider Article 21 and Article 22. Now, when it comes to bail, I always face questions in law schools, in our workshops in judicial academies, and various conferences where very educated people attend those, maybe conference of doctors, chartered accountants. I have participated in several legal workshops of doctors. Most of these persons who have not studied law, they do not understand difference between release of accused on bail and acquittal. They equate bail, grant of bail with acquittal. It is not confined only to the lay persons in the sense highly educated persons, but those who have not taken education in law. I attended a conference of National Judicial Academy, presumably at Patna, where it was a training seminar for newly appointed High Court judges and newly appointed Sessions Court judges. There was a top law officer, Additional Solicitor General of India, who is one of the top ranking brains in tax matters. So he said, sir, I give you assurance that whatever is discussed, I will not disclose, I will maintain confidentiality, but permit me to attend your session. It was again on law of bail. In question and answer session, he asked me a question. Sir, I want to ask you a question. There are very serious economic offences involving very large amounts. The offences which allegedly affect the entire economy of our country. And courts are granting bail. How do you explain this? I answered the question by relying upon Article 21, that no one can be deprived of his liberty except in accordance with procedure established by law. And that procedure is not mere procedure. That procedure has to be just, fair and reasonable. It cannot be arbitrary. It must stand scrutiny of Article 14 and other fundamental rights. So I answered the question by saying that if within four corners of law and established tests laid down by the courts for grant of bail, if a person is entitled to bail, it is the duty of the court to release him on bail, notwithstanding the magnitude of the crime, the seriousness of the crime. And I want to repeat what I said. If before a court of law case is made out for grant of bail, the person cannot remain in custody even for a second. The reason is that if it is proved before the court that a person is entitled to bail, and if he is denied bail, it is violation of his fundamental right under Article 21. And before we go to bail, we must understand the safeguards provided by our Constitution against the arrest. Those safeguards you will find in Article 22, clauses 1 and 2. The first safeguard, and which is a topic of discussion, some of you must have read recent judgments of the Supreme Court. The first safeguard is, after a person is arrested, as soon as possible, he must be informed about the grounds on which he is arrested. Grounds of arrest have to be furnished to him, maybe orally, maybe in writing. And second and most important is that whenever a person is arrested, he must be produced within 24 hours from the time of arrest before the nearest magistrate. So these are two very important safeguards. And these safeguards you will find are reflected in BNSS, which is now the Criminal Procedure Code, which was brought into force in 1994. Now, the Criminal Procedure Code or BNSS provides that no person who is arrested without a warrant can remain in custody for more than 24 hours unless his detention is authorized by a magistrate having jurisdiction. Therefore, please remember one thing, if it is proved before the court, even before a magistrate before whom the accused is produced, that he is produced, of course, time required for traveling from place of arrest to the court of magistrate has to be excluded. But if it is proved before the magistrate that he was kept in detention for more than, even 1 minute more than 24 hours from the time of his arrest, it is the duty of the magistrate to forthwith release him, because the moment 24 hours period is complete, his arrest is rendered illegal. Same is the case with furnishing grounds of arrest. And now Supreme Court has recently gone to the extent of saying that as soon as possible, grounds of arrest must be informed to the accused. And in any case, at least 2 hours in advance in writing before he is produced before the magistrate. Even in this case, if grounds of arrest are not furnished as soon as possible after the arrest is rendered illegal and unconstitutional, person has to be released. So, why I am telling you this? Constitution, the intention of the framers of the Constitution is to protect people from arrest, arbitrary arrest, illegal arrest. That you must remember. One more concept I want to tell you that is supported by the provisions of BNSS. Let us take a case of any offense, cognizable offense, very serious offense. FIR is registered. It is not mandatory for the police to arrest suspect or accused. It is not mandatory at all. And that is reflected, clearly reflected, not only from our constitutional philosophy, but section 35 of the BNSS, which lays down in which cases an accused can be arrested without warrant. And if you find subsection 1 of section 35, it says that any police officer may, without an order from magistrate and without a warrant, arrest any person. It's may. It's not shall. Why accused is required to be arrested? Please remember one thing. Accused is not arrested per se on the ground that the police officer believes that there is material available against him which indicates, or there is suspicion that this person must have committed the offense. That is not the ground. What are the grounds? His custody is required for the purposes of investigation. This is one of the grounds. The second ground can be that the man is history sheeter. He has committed several offenses. He has been convicted. Or maybe in earlier case he was arrested, released on bail, then he had jumped the bail. The third is propensity of that man, or sometimes the position of in the society of the victim of the offense or the eyewitnesses. So, if it is perceived that there will be threat to the witnesses or the man will try to tamper with the evidence, that is a ground for arrest. And one more ground is, it is quite possible, looking to the propensity and history of the accused, that he will ensure that trial is delayed. So these are the grounds enumerated in section 35. Of course, those grounds are in case where the offense has maximum punishment up to 7 years. But even in case of a cognizable offense where sentence exceeds 7 years, life, or even capital punishment, it is not mandatory to arrest the accused. I'll give you one illustration why custody of the accused is required for investigation. Because during the investigation, police officers record statements of various witnesses, and they want to confront the accused by telling him what the witnesses have said in their police statements. And there are cases where, suppose it's a case of murder, and the weapon used by the accused is not recovered, weapon used to kill the victim is not recovered, then for the purpose of recovery, the custody is required. And all those protections we will find in BNSS, that immediately after his arrest, he should be informed about the grounds of arrest. He should be also informed. I am talking about cases where person is arrested without warrant in a cognizable case. He has to be also informed by the police officer that he has right to get bail, right to apply for bail. All those safeguards have been provided. Now let us come to the bail. I'll come to what Justice Krishna here said. But please remember one thing. When accused applies for bail and bail is denied to him, bail is denied to him not by way of punishment. Please remember one thing, in our jurisprudence, person can be punished only after his guilt is established before the regular criminal court and guilt is established beyond reasonable doubt. So, when the court rejects bail application, it is not with the object of punishing a person, because you can't punish a person unless his guilt is proved. So please remember this. You know, in our society, the demands are different. There is a heinous offense committed. Common man does not understand our jurisprudence, and therefore there is a demand. Arrest the person and don't release him on bail. Not only that, our politicians cross limit. Our politicians go before media and they pronounce that, look, we have arrested a person, we will see that he is hanged. It is only the function of the court to decide whether person is guilty. And even if he is guilty, it is the exclusive domain of the court to decide whether person should be sent for life imprisonment or for capital punishment. But these are the things which happen, and therefore there is a demand. Don't release a person on bail. Or when court releases a person on bail, social media erupts, electronic media erupts, and the courts are criticized. So please remember this. Denial of bail can never be by way of punishment. Now, basic rule you must remember that within 24 hours of arrest, person has to be produced before the magistrate. And then we come to what is known as remand. All those words you will not find in CRPC or BNSS. What is remand? That police produce arrested accused within 24 hours before the magistrate. They submit a report to the court and they seek police custody remand. They seek police custody. And there are provisions now in BNSS that maximum number of days in which he can be kept in police custody can be only 15. It can be, of course, spread over for 40 days or 60 days. So that is the first stage when the accused is produced before the magistrate. Keep aside cases where there is life imprisonment or death penalty. Even when accused is produced after he is arrested without warrant before a magistrate, on the first date, magistrate has power to release him on bail. Because when accused is produced, you must be reading in newspapers that lawyers come and apply for bail while they oppose the grant of remand. So entitlement to bail starts from the moment accused is arrested. Now there are different categories of bail. Now one category which is popularly known as default bail, again those words you will not find in the statute. Now that provision under the new BNSS is in section 187. Now this provision says that in lesser offences, investigation has to be completed within 60 days. And in other cases, it is 90 days, where offence is very serious. I am not